presentation. I have the clock here and I'm ready to go.
Good morning, Your Honors.
And
May it please the court. I am Brandon Vesley of the Florida Appellate Firm. I'm here representing the appellant, Dominic Kaludis. He's also the cross appellee in this appeal from a domestic violence injunction. Your Honors, the DVI is a major restriction, limitation on Mr. Kaludis' constitutional rights. He is an avid gun collector. He is former Air Force, former police officer for 20 years, and he had extensive gun collection, and he's now prohibited from possessing any gun. He was also removed from his home that he built, and he lived in with the petitioner and the children for many years, even though he was the named trustee for the trust for the house, and it was in for the benefit of the children. And most importantly, the DVI is a black mark on my client's record, which affects his ability to work. This is why procedural due process in this case is of utmost importance. My client has every right to challenge the charges against him, and he was not properly advised of what these charges would be. So our first argument on appeal, Your Honors, is that the final injunction for protection against domestic violence was based on unpleaded allegations and violated his due process.
before you begin the entry to that argument, let me clear up one point so I make sure I have it in my mind. At the hearing below, did your client raise an issue invoking a violation of protection supported by the Second Amendment? The right to bear and carry.
My client didn't testify, Your Honors, because of Fifth Amendment
issues. Okay, so neither he nor counsel raised it then, is that correct?
Not regarding the Second Amendment, no.
I have a vague recollection at one point Judge Silverman authored a panel opinion dealing with something to do with domestic violence and weaponry. And the reason I remember because I was on the panel. No. I don't remember the case itself, and nobody raised it, so I assumed it wasn't preserved. That being the case, then we'll let you go into your due process argument. Thank you.
Sure, Your Honor. I recognize where you're going with that. We did not raise that argument on appeal or at trial. Procedural due process requires the litigants be given proper notice and a full and fair opportunity to be heard. That is directly from a domestic violence case, JGG versus MS 312 Southern 3rd 509 out of the 5th DCA. Your Honors, adequate notice must provide some indication of the witnesses to be called and the evidence to be utilized to prove entitlement to relief. More so under Section 74130 3A under the Florida statutes, the sworn petition must allege the existence of such domestic violence and must include the specific facts and circumstances upon which the basis for relief is sought. So in this case, Your Honor, if you look at the domestic violence petition, and please recognize that this domestic violence petition was filed pro se by Ms. Ferrentados.
Vesley, most of them filed pro se. I don't see where the statute has any pleading limitations. This petition clearly says I've been abused for several years. A simple deposition could have ferreted that out. That wasn't done. I don't see where the sufficiency of the petition was attacked pre-trial. And then during the trial, I can only see where Mr. Hebert objected to cumulative, speculative. He never lodged any objection to put the trial judge on notice of any due process violation. The only objections were cumulative, objection to hearsay to the phone call and Ms. Breen, speculation to Mr. Ho, and cumulative as to Mr. Lanzar. So where in this record was the judge put on notice that your client was claiming a due process violation for failure to plead these specific incidences?
The first time, Your Honor, was on page 50 of the 873-page transcript where Mr. Hebert argued that the allegations being raised were not addressed in the four corners of the complaint. That's exactly what you're talking about. He specifically raised that argument, and he parroted that argument later on, but he didn't do it after every instance because the court made it crystal clear that it was going to allow any information about any incident that ever happened in this case to come forward because she checked a box that said she had a history of domestic violence. Your Honors, the problem here is, even if the court recognized that maybe they could have some degree of history in this case, the court ended up relying on 4 of those multiple incidents that were never raised in the petition. And we argued vehemently at court that they were irrelevant, that they didn't belong in this case. And the court just said, no, I'm going to allow anything that they want to talk about because she checks the box that said there was some history of domestic violence in this case. Your Honors, I also want to point out here that this domestic violence petition was filed a day after Ms. Ferrentato said game on. And my point there is she's hearkening back to events that happened in a long time ago. This is not something where a typical domestic violence petition, somebody does something, creates some domestic violence, and the person goes right to court and files a domestic violence. These are all incidents that happened years ago. Many of them happened years ago. She cited to one incident that happened in 2022, which is the same, within a few months of this, but that one the court didn't even rely on in its ruling. So, Your Honors, I recognize that he raised an argument that we did not preserve the due process argument, but we did preserve the due process argument. And the courts do not require a counsel to continue to object to something when the court has made it crystal clear that they're not going to grant that objection. It's futile at that point. Your Honors, the pro se domestic violence petition did not satisfy due process. Again, all but one incident were general allegations and not specific in the actual petition. And Your Honor, you're asking us to ferret out what she's arguing. It's their burden to plead it specifically under the statute. And if she didn't plead it specifically, she certainly could have amended her petition. She ended up having multiple lawyers on this case, and they could have easily amended the petition that was written pro se, but they didn't.
Wesley, let me ask you a question. As far as the due process argument, is there a prejudice component that comes into the analysis?
Prejudice to my client?
Yes. Is there a prejudice component that your client, if there's no indication that your client was not prepared to go to trial, your client wasn't prepared to set forth its view of the case, cross-examine witnesses, and so forth? Is there a due process aspect?
Absolutely, Your Honor. The due process.
Okay, so if there's a due process aspect, where does your client's counsel indicate that, Judge, I'm not prepared to go forward if you're going to let all this information in. I'm not prepared to cross-examine these witnesses. I didn't have any idea any of this was going to be a part of this case. Your counsel at trial does argue relevancy, argues that it wasn't fully pled, but is there any argument that I'm not prepared to go forward, my client's prejudiced by all this because we didn't know any of this?
Your Honor, I mean, he may not have articulated it exactly like that.
You just said that prejudice is a component. So show me something in the record that establishes counsel was not able to go forward and adequately represent your client.
Like I said, I think the page 50 of 873 is where counsel talked about the fact that it was not pled. It was not in the 4 corners of the complaint. I think it's implied.
And I understand all that, Mr. Vesley, but I am trying to get my head wrapped around the idea of how has your client been prejudiced at trial based on the failure to plead more information? Because counsel doesn't seem to ever say that. In fact, counsel seems to have done a pretty good job of cross-examining each witness.
Well, hats off to Mr. Hebert for stepping to the plate and trying
absolutely.
to
Absolutely. And Mr. Hebert may have had all the information he needed to do this. And so the due process violation requires some showing of prejudice. And I'm looking for that to be able to see how the due process is going to be a winning argument for your client.
Well, certainly, Your Honors. You know, when Mr. Hebert is up there cross-examining these witnesses, he's doing in the cold. He's never had a chance to even identify them as witnesses. So you know, he did the best he could, but obviously, if he had known in advance what the specific allegations were, again, her petition was very general and didn't have much specifics at all, dates, times, anything like that. And when he's up there arguing this, he's just arguing it in the cold, and he's never had a chance to really understand these arguments. Could he have done a better job? I think absolutely, if he would have had the information, but the court prohibited him from having that. I mean, did he have to say that he's been prejudiced? I mean, he argued that these allegations were not in the four corners of the complaint, and therefore, obviously, he was unprepared for them. I don't know if he has to specifically say that he was prejudiced. I mean, it's obvious, isn't it? It seems implied to me that's why he's making the objection. He also argued relevance, and relevance is important because relevance on some of these things. I mean, if it's not part of the petition, how is it relevant? And
Mr. Vesely, I think one of the concerns, if I might tap onto what Judge Silverman said, and I may be wrong, is that oftentimes when counsel objects and provides their objection, they might also, if it's prejudicial, propose a cure. Judge, this is beyond the corners of the document. I'm not prepared. And the cure I would propose is a continuance, even if I can take her deposition outside the courtroom. And I think what Judge Silverman may be driving at is that he didn't see any request that would inference a prejudice because there was never a remedy sought either.
Well, the objection was overruled, and I don't think he wanted to continue the fight at that point when it was overruled.
Having been a trial judge, I understand that commentary. Don't want to alienate the mind you're trying to convince.
And Your Honors, also these errors were not harmless because the incidents that the court recognized in its findings at the conclusion of the hearing were all incidents that were not pled. So it's very important to understand that, you know, the court didn't just allow these in as history of their case. The court allowed these in and then relied on them in making its determination. And I think that is this case is much worse than any other case in Florida jurisprudence where courts have reversed for not pleading the specificity required to bring these issues before the court. And this, you know, we're talking about numerous incidents, and the court relied on them. So, you know, I don't see how this court could ignore that just on the basis that Mr. Hebert didn't argue that he wanted a continuance when the objection was overruled in the court, and he was required to go on, and that allowed the witnesses to continue testifying.
And Mr. Vesely, which page of the transcript did you say this page 50?
50, Your Honor.
Very good.
And there's if you look at my brief, there's numerous citations as to where the objections were made. It's just that objection 50 on page 50 is specific to this wasn't raised in the four corners of the complaint.
Right.
Okay, and the other ones, some of them said relevance, and Mr. Solario pointed out that that's not actually a due process argument. That's a relevance argument. But the point is they weren't relevant when they weren't mentioned in the complaint.
Why wouldn't it be relevant if she stated under oath, I've been abused by him for several years? It's just a simple matter of attacking the sufficiency of the petition by way of some type of motion, taking her deposition. I understand there's certain strategic decisions trial lawyers make, but there was nothing done to prepare for this trial, period.
Your Honor.
Not one bit of discovery.
Well, there was only a couple of weeks. You know, there's a requirement that these matters are heard almost immediately. So
I understand
in terms
that.
of discovery,
Where's the surprise? I mean, Mr. Hebert didn't say, I'm surprised by Mr. Lanzot. I'm surprised by Miss Breen. Never heard of it. That's not in there.
Your Honor, you have to recognize that the general nature of the pleadings, which she's required to present her pleadings with specificity under the statute. The general nature of them became specific at trial. So what she alleged was I was abused many times in the past became specific dates that she was testifying to, and they weren't part of it. So obviously she worked with her counsel to come up with, you know, how they were going to present this. Why did they not amend this? Why is it on my client's responsibility, when the statute requires specificity, my client to ferret out exactly what these pleadings were?
Mr. Vesely, could Mr. Hebert have asked for a continuance?
Excuse me, before Mr. Vesely, we are now embarked upon 15, so you know to use your time responding to the question.
I'm at 15 minutes, Your Honor.
Beyond, but I'm going to treat it at 15.
Okay.
So you may answer the question and then we'll move.
I do not believe he asked for a continuance, Your Honor, but I would have to go back and check.
No, but he could have, correct?
Sure, he could have. Yes, he could have. Your Honors, I also want to point out that quickly that if you look at just the findings that the court made and the witnesses that the court found were credible, those findings that the court made don't amount to what should be considered domestic violence. They're very general. They don't. No person ever observed any domestic violence, and that there's no evidence that anybody ever observed it. And the four witnesses that the court cited to, Frederick Ho, Ms. Batista, Mr. Lanzot, and Mrs. Breen, they bring very little to the table as to what could be domestic violence. I mean, I could go through each one of them, but it's in my brief, and I know that I'm running out of time here, so I don't want to take that time. But it's very clear in my brief. I actually cited the testimony. They have very little to offer in terms of what could be domestic violence. Lastly, on my case in chief here, Your Honors, I wanted to point out that the motion to disqualify that was raised was erroneously denied because we weren't given the opportunity to conduct discovery. You know, all the court needed to do was give us limited discovery. Ask Mr. Phillips if he conveyed any information to Mr. Foster regarding this domestic violence case. One simple question, could have been an interrogatory, but the court specifically prevented us from taking any discovery, and for that reason, this case ought to be reversed also. I will save the rest of my time, I guess, for the response to the cross appeal and to unlimited rebuttal. Thank you.
Thank you, counsel.
Good morning, and may it please the court. My name is Sam Solario, and I represent the appellee cross appellant Nicole Ferrentatos. I think I just want to start. I don't want to talk too much because we've said pretty much everything that we need to say in our briefs, I think. But I want to talk a little bit first about preservation around the due process argument and maybe be clear about what some of the facts are around this. This petition was filed on March the 11th, 2022. It was continued for trial 3 times. First in March, again in April, again in May after the appellant filed his disqualification motion. It was ultimately heard over 3 days on July 27th, August 17th, and August 22nd. So there was ample time between the filing of the petition and the trial for the appellant to have made a motion to dismiss because the petition wasn't specific enough, for the appellant to have made a motion for a more definite statement because he didn't feel like he had all the particulars he needed, or for the appellant to take discovery around some of the allegations that he now deems on appeal to have been too general. So this was not the typical domestic violence injunction case where there's a very truncated time between petition and trial. This thing was more drawn out. There was ample opportunity for appellant to have sought a better pleading or to have sought discovery. In fact, appellant did seek discovery. There were requests for admission filed by the first lawyer involved for the appellant directed to the authenticity of emails. And then if you look in the record, I believe it's going to be at pages 597 to 717 of the record, you will see when the appellant launched his disqualification motion just a couple of days before the trial was supposed to begin in May, he served a spate of 11 subpoenas seeking everything under the sun, but nothing related to putting meat on what he now contends to have been the bare bones of the allegation of the petition. So this was a case where the appellant made a choice. He chose not to move, he chose not to seek the discovery he needed, and he went to trial as pleaded. Second, Judge Silberman, to your question, I think what this record demonstrates is that the appellant was perfectly able to cross-examine these witnesses and to present his own evidence that rebutted those witnesses. With Ms. Breen, for example, he was able to ask her about, did you witness any of these events? He was able to try to impeach her with a letter that she wrote in support of appellant at a criminal sentencing at a criminal trial in Las Vegas. He was able to impeach her with a text message with the appellant. This was not a case, similarly, with respect to Mr. Lansnott, who testified about appellant's collection of firearms. He was able to bring in his daughter as a rebuttal witness to testify about a gun trust that the appellant claimed to have had. He was able to cross-examine Mr. Ho, saying, well, isn't it the truth that Mr. Kaludis was just making a joke and he was making an analogy to the movie Analyze This, when he made the gun sign to his head and talked about throwing her in the trunk after he had shot her. So this is a case where the record amply demonstrates that the appellant had the notice that he needed. Secondly, just on the merits of the due process point, I think the most analogous case here is the 3rd District's decision in Faddis. That case, like this one, was a case where the petition alleged one specific instance of domestic violence and then described in more general terms other instances of domestic violence. And what the 3rd District said there was that the general allegation was sufficient to put the perpetrator of the domestic violence on notice of what it was that the claimant was alleging. And he, like appellant here, was able to frame his own cross-examination and defend those allegations. And I think it's worth noting in this case, this is not a case like the 3 that the appellant relies on here. This isn't like JCG. This isn't like Sanchez. This isn't like De Leon, where what you have is a bare bones petition that alleges 1 or 2 events and nothing else. I mean, this petition alleged that Ms. Ferrentatos, quote, I've been continually abused for several years on and off, physically and continuously, verbally, mentally, and emotionally by Dominic S. Kaludis. Then she says, quote, over the years, he has thrown me through drywall, chased me down streets, punched me, choked me, thrown me to the ground, and punched me in my head and back multiple times. She alleges the existence of guns. She alleges threats to take the children away. All of the evidence at trial was consistent with those general allegations that nobody ever sought any further clarification about. And so, like under Faddis, this is a case where the appellant had notice of what it was that Ms. Ferrentatos was claiming and was able to put on a defense that he meets the test of due process. To the preservation point, I really do think that the trial court would be completely surprised to find out that it was getting reversed on the basis that Ms. Breen's testimony about other incidents of domestic violence, that Mr. Lansnott's testimony about the existence of guns, and that Mr. Ho's testimony about the gun to the head threat violated due process. To begin, there was no objection made as those witnesses testified. And I think if you look at this record, and we've kind of spelled this out in the facts section of our brief, the only place that there is an objection that could even be remotely considered close to, Your Honor, my client's due process rights are being violated, we don't have notice, is at pages 50 to 51 of the transcripts. And what happens there is Ms. Ferrentatos begins to testify about an event of domestic violence in 2000, and I want to say it's December of 2021. Mr. Kaloudis objects this is well beyond the four corners of the petition. And then when the judge says, well, I think it may be outside the scope of the written narrative, but it's within the prior acts of domestic violence section, all he says is, well, we'd like a date in December if possible. Putting to the side that that is not an objection to different evidence by different witnesses weeks after this evidence was offered, it's not even an objection that asserts the argument that they're making on appeal. I mean, imagine a universe in which the appellant had said, Judge, we had no notice of this. We're completely surprised. My client's due process rights are being violated. That might have prompted a very different discussion with the trial court. Instead, all the trial court knew was four corners. The trial court looked at the four corners and said the four corners contain prior acts of domestic violence. This issue was just not preserved. And we have walked through this in the rest of the brief, but the only other times appellant objected and said four corners, I think they were twice. He never got a ruling on it. And what is the trial court supposed to make of relevance? Relevance could be any number of things. What it certainly is not is a specific objection on due process or statutory grounds. So I think for those reasons, the due process argument is fairly easily disposed of. On disqualification, I want to talk about two things that the appellant just doesn't have an answer to, and one thing he answers, and it's just not convincing. The two things he doesn't have an answer to are, one, the rule of Younger Utility versus Myers, which we discuss in the brief. And this is the idea that when you forego your interlocutory remedy, and here he could have taken a Rule 9.130 appeal of that disqualification order, when you make the decision, when it's your choice to forego that remedy and proceed to trial, you've got to show prejudice from the use of client confidences after trial. Not only is that rule not acknowledged in the initial brief, it's not acknowledged in the reply brief either. And it's never been attempted to be shown that that the other side actually used confidential information against us. That alone, I think, is reason for the disqualification issue to go by the wayside. You know, I think that also just kind of filters into harmlessness. Like if you wanted to look at it from a harmless error perspective, here you have a case where all of the witnesses who testified were either Ms. Ferrentatos' friends and employees, or Ms. Ferrentatos' retained investigator. Anything that was offered was stuff that she knew or had ready access to, and there's no reason to believe that it would have contributed to the result that there might have been some hypothetical speculative relationship between Ms. Ferrentatos' counsel and who Mr. Kaloudis alleged to be his prior counsel.
Larry, was anything raised at trial as far as an objection to information that reflected confidential information was being used?
None. There was an objection. There was a renewal of the disqualification motion at the beginning of trial, but there was never any objection at trial, and there was never any post-trial motion making the argument that, hey, when you look at this body of evidence, it's clear that she's been using stuff that was confidential as to me. But that gets me to the second point that the appellant doesn't have any answer to, which is the commentary to Rule 4-1.9 and this court's decision in Goff versus Goff, both of which basically say there's not a confidential information problem when the evidence that the allegedly adverse party is using is evidence that's either known to them or that any reasonably competent lawyer would have picked up in the course of the representation. And here, again, Ms. Ferrentatos was a victim of domestic violence. She knows when the appellant beat her. She knows when the appellant threatened her. All of the witnesses are people who are either known to her or who she hired. So there's no reason to believe that, well, not only is there no reason to believe she wouldn't have come into this into her evidence independently, she came into the evidence because she's the victim and she knows the witnesses. She either knew this stuff or any reasonably competent lawyer would have picked it up. The third point, and that's just where the appellant is unconvincing, is all it would have taken was one simple question. But that's not what the trial court was confronted with. The trial court was confronted with a sprawling disqualification motion, like 58 pages, alleging 11 separate ethical violations, filed 2 days before trial when the intervening day was a federal holiday. So it was filed on a Sunday. Monday was Memorial Day. Tuesday trial was supposed to start. An appellant drops a bomb of a disqualification motion and then tries to prove it up, not with a simple question about whether or not confidential information has been used, but with a sprawling barrage of 11 different subpoenas, seeking stuff that's obviously privileged in the case of the subpoena that was directed to Ms. Ferrentatos' lawyers, or that was just facially absurd. I mean, one of these subpoenas was directed to Stetson Law School and sought grade distribution records for one of the lawyers at Barnett Kirkwood who was an adjunct professor there. So when you are reviewing the trial court's decision to grant a protective order for abuse of discretion, this is a case where the trial court saw quite correctly that this was a fishing expedition launched on the eve of trial, directed to the important right that a party has to retain counsel of choice. I just don't think under that standard, this is at all impeachable. I really don't have much to say on the cross appeal other than to hit one point. When you look at 741-36C, what you see is a statute that says these two injunctive provisions, that is to say, the one restraining domestic violence and the one imposing additional conditions for the protection of the petitioner, shall remain in effect until modified or dissolved. That was an amendment to a prior statute that just basically said all of the injunctive terms can exist for only a year. If you look at the law of Florida, and it's Chapter 7-155 that adopted it, it's in the title. This is an act revising the period during which injunctive relief remains effective. We've made the case in the brief. I don't need to repeat it here that the plain language of that statute means what it says. It's effective until there's a modification or a dissolution, which the appellant is free to seek once this appeal has been disposed of. The only real argument they have is one line in a 30-year-old rules opinion that says, we do not believe that the legislature
You're at 15, by the way. I'm late with you as I was late with Mr. Vesely. So we're starting 15 Your Honor. Now. It's up to you.
I'll just finish up real quickly. We don't believe that the legislature has the ability to restrict the trial court's discretion with respect to injunctive terms. You know, rules opinions aren't precedent. That one sentence is not an explanation. The statute says what it says. You know, there's not been any kind of separation of powers or other kind of argument made here. So we think that the statute means what it says. And thank you for your time.
Thank you, Mr. Solario. Before we go on that one, I do have one question. Part of which I have to confess is colorable by experience on the trial bench. As I look at subletter C, and it says shall remain in effect unless modified, often trial courts are confronted on hearings to enforce with evidentiary matters saying, well, she said, he said it was okay. Don't worry about it. You can come by. This one would alleviate the trial court's concern about such factual evidence and said the legislature has precluded that, whatever. So part of it is colored by that. when I go to the language of the statute, it says the terms of the injunction, which strikes me, and I would like your point of view, is terms doesn't include duration of the injunction, because terms seems to follow from what appears in the paragraph that you cited, sub 8, ordering relief necessary for the protection. And I know that may be a very fine line to draw, but I'm thinking of, if I read that in conjunction, pari materia, with 8, I say you can't come within 500 feet. You can't do this. You can't do that. All these are the conditions that are necessary, as the statute says, for protection. It doesn't invade the trial court's authority to establish a term. So I want to, is term broad enough to include duration as a term? Or is it the terms that they refer to in 8, as you cited in your brief, ordering such other relief as the court deems necessary for the protection? And that's kind of what I'm focusing on, is the interplay of those words. And maybe I'm making much to do of nothing, but since I have the benefit of people who spend a lot of time dealing with interpretation of language of contracts and statutes, I get to ask the question and get the benefit of all their research, which means you and Mr. Vesely's response.
So we've obviously cited to you the Bacchus versus Bacchus case, which says that what the statute means is that the provisions of those two provisions remain in effect indefinitely unless modified or dissolved. That's a case out of the 5th District. So we think you already have authority supporting our interpretation of the statute. But, you know, just to kind of take it from a first principles perspective, right? I mean, what the Supreme Court has been saying recently is, you know, the meaning of the text is controlling, and what the words mean in their context is what the statute means. And our view is, in context here, the word terms is most naturally read as referring to the 8 types of injunctive provisions that a domestic violence injunction can contain. And we say that for 2 reasons. One, because it's part of the statute that immediately precedes it, and the statute is concerned with what does this final judgment of injunction say. And then secondly, because the statute then proceeds to carve out 2 specific items from that list of 8 items that the court can include in a injunction. The requirement that you refrain from future domestic violence, and then the kind of any other provisions necessary for the protection of the petitioner, right? And by carving those out, what it is saying is it is those terms that remain in effect until otherwise modified or dissolved. I don't think if duration was just a term that the legislature would have picked 2 specific types of injunctive relief and said it's those and not any other that remain in effect indefinitely until modified or dissolved. Is that responsive to your question?
Yes, sir. Thank you. Okay. Mr. Vesely, let me turn off this time clock so it doesn't tell you that you're totally out of time here. You have 3 minutes remaining.
Thank you, Your Honors. Regarding my first in rebuttal to his argument regarding my case in chief here, Your Honors, all of what I've heard today is suggesting that the onus is on the respondent to ferret out, figure out, discover what the petitioner means by her general allegations. Take discovery, go, take depositions, move to dismiss it if it's not clear. Your Honors, it should not be on the respondent to do that. The respondent can rely on what the petitioner pleads. She had a team of lawyers who could have amended this petition, who could have argued, who could have specifically stated, these are the allegations that we're going to go forward with. They didn't do that. They left it the way it was because they knew that they could then surprise counsel and bring a lot of this to to the forefront at the final hearing. Your Honor, the fact that Mr. Hebert was able to do anything with these things is really applaudable for him. But, you know, if we had known the specific allegations the court was going to rely on, there would have been a lot more information to be presented at the trial. You know, we found out just before the trial that there were guns in the car, in the Mercedes that was at the house, under lock in the car, in the locked garage, in the locked house, behind the locked fence. But that information was something that the court relied on to say that she had a reasonable fear for her safety, because there were guns that were not turned into the police, which ultimately became a criminal contempt hearing, which caused my client not to be able to testify. So, you know, I don't think the court, if the court is going to affirm this, the court needs to write an opinion and say the onus is on the respondent to go forward and figure out what these allegations are that were general allegations.
I don't want you to misunderstand what we're saying, but counsel below acted as if this petition was sufficient. Now you're arguing that it's not. And our point is what did you do about it to determine the sufficiency? When it says, I've been abused for years, and you have the fattest decision out there that's been out there for quite some time. I think her petition is a little more detailed and specified than the fattest petition. She doesn't give the dates, but she certainly gives the specific types of physical violence perpetrated upon her at on different dates and different years. We're not saying you have to do anything. We're just saying nothing was done to this petition that you're saying was vague.
Your Honor, those allegations were not what the court relied on. The court relied on what Jeremy Lanzot said. He found guns in the car. What Frederick
the court looked at her petition and said, I was abused over the years, and said, hey, unless I hear anything else, this is relevant. Because Mr. Hebert didn't make any other specific objection other than outside the four corners. And the judge looked at the petition, like Mr. Solario was saying, and said, well, this is over a number of years, so it's relevant.
So in terms of admissibility of that information, there may have been something to that effect, but the fact of the matter is the court relied on specific allegations that were not even addressed in her general allegations. And those had an impact. And there's case law that says if the court is hearing things that were not raised at all, then you can't assume that that did not have an impact on the court's ruling that domestic violence occurred. So, and I cited a case in our brief that talked about that. So you have things like the Lanzot finding the guns, the Frederick Ho, the incident with the bodies in the car. None of that was in the petition at all, even in general form. Ms. Batista's, same thing, Your Honor. It's not in the petition. It shouldn't have been relied on by the court. It was a due process violation, and I think Mr. Hebert did a reasonably good job in pointing out and making objections when these things came out.
Well, she checked the box that he owns handguns and rifles, plural.
And she did not check the box that she was in fear of his handguns, and 4F, I think, is the box that she didn't check. So, Your Honor, the fact that there was guns in the behind locked doors, they were in her possession. These guns were in her possession. I think I need to turn my attention to the cross appeal real quick.
I think we have gone well past 3 minutes. We're at 5.5 now. But I'll allow you at least 30 seconds to respond to that, so we get at least a little bit of an argument. And I'll afford Mr. Solario an extra 30 seconds as well.
I appreciate it, Your Honor. You know, it's actually part of the rule of family law procedure here in this state that the court can select a term of time for its domestic violence injunctions. That's what has happened here. This court is absolutely correct that the word terms would be surplusage if it didn't have a meaning. And the terms this court selected specifically in its order, it says the term, and it says the term of this domestic violence injunction is 4 years. So, Your Honors, we believe that that is exactly what the court did, and it was correct in doing so. Also, the Supreme Court pointed out in its opinion regarding that rule change that it did not think that the legislature had the authority to restrict the amount of time to not allow a trial judge to restrict the amount of time for a domestic violence injunction. That's all, Your Honor.
Thank you. That will conclude this presentation for the appellant. We will let me clear the clock here and go to Mr. Solario. Since I said I would give you the same extra time, I'm not sure you'll need it all, but you were going to have 4, now you have 5 since he actually got an extra minute.
Yep. So I think on this one, I'm just limited to the cross appeals. So
correct.
What I would just, and I don't really have much to say other than on the family law rule of procedure, we've suggested to you in the reply brief a way to harmonize the rule and the statute to avoid the kind of constitutional problems that would obtain if you were to interpret a rule of procedure as trumping the requirement of a statute. We think the two things can be harmonized. It's there.
So, Mr. Slater, the legislature is clearly understanding of its responsibility and ability to modify statutes as necessary. They were presumably aware of the Supreme Court's position on terms. And one thing that nobody's really discussed, but I wanted to throw out there, the legislative language as far as it shall remain in effect until modified or dissolved. Couldn't that be an effort by the legislature to basically preclude and make clear that parties cannot agree to ignore certain provisions of an injunction or to modify certain provisions of an injunction without a court order?
I think, well, I guess there are two things I'm hearing in your question, and I'll deal with the last of them first. I think if that is what the legislature meant to do, it chose an awfully broad way of doing it, right?
Well, they also chose a very narrow way of dealing with terms, because they could have used language that was more definitive, saying a permanent injunction on these two topics has to be permanent and not reduced by any term, absent a motion to modify or a motion to dissolve that the court considers.
Although I think that's consistent with and we've explained this in the initial brief on cross appeal, that's actually consistent with the ordinary meaning of the words remain in effect. That is to say, to say a condition remains in effect until something else happens necessarily implies that condition is operative until that other thing happens. And here, the only other things are modification or dissolution. Like if the legislature had meant to say it'll remain in effect until expired, it would have said remain in effect until expired, and it didn't do that.
One thing I want to raise is, one thing I'd like to raise, Mr. Solario, is Ms. Bacardi below asked for 5 years. The court said 4. Now, she was able to preserve a certain objection, but I think that your argument as to Mr. Hebert's objection should hold true for this one. She didn't really say it should be indefinite. The statute doesn't say indefinite, and I think we would all agree trial judges have broad discretion when imposing an injunction. If we are to read in that a permanent injunction is always indefinite, aren't you eliminating a trial court's discretion? It's like mandatory sentencing. I know it probably shouldn't be titled permanent injunction because it's really not permanent. But if you say that every permanent injunction that is imposed and entered must be indefinite, you're removing a trial court's discretion.
So let me say two things. One, on the preservation piece, if you look at page 879 of the transcript, you'll see the objection that this needs to be permanent. Secondly, I don't think the concern about limiting the trial judge's discretion is as operative here as it is in the hypothetical you provide. because modification and dissolution are themselves discretionary remedies, right? And I think the court's body of case law on this is, hey, listen, when the judge determines that the circumstances that created the need for the injunction in the first place don't really exist anymore, the court can dispense with the injunction. And I think that's really all the statute does, is it says with respect to these two provisions, which are really the most essential ones, right? Like, don't commit violence against the petitioner and abide by these things that I am devising specifically to protect this petitioner. It makes sense that the legislature might say, unlike the others in the list, we want these to remain in effect until the trial judge makes a considered decision that they're not necessary to protect the petitioner anymore.
I believe that will then conclude the presentation. I say that based upon the power invested in me by Chief Judge Sleet to handle this case as the primary center chair judge. I thank both counsel for their presentation. I speak on behalf of the panel. It was the most interesting presentation, and we thank you and wish you Godspeed and safe health.
Good to see you both. Thank you for letting me sit in. Good to see you, counsel. Have a good day.
Thank you very much.
We'll move to the second case on our docket this morning and have the counsel for Walker versus Banker of Life transferred in. We now have a new complete panel. Judge Labred has joined us. Good morning, Judge Labred.
Good morning.